Good morning, everybody. Welcome to the Schoeneck King Summer Webinar, Top 10 Special Education Tips for the Upcoming School Year. We're happy you're able to spend some time with us this morning. We're going to be here from 9 o'clock to 10:30 a.m. And I want to start. My name is Jeffrey Weiss. I'm a partner at the firm. I want to explain what we're going to be doing today. We're focusing on getting ready for the upcoming school year, and we're giving you 10 practical tips for you and your special ed staff as you prepare for the upcoming school year. We're focusing on practical tips to help enable you to fulfill all your special ed legal requirements. And we have a couple of honorable mentions at the end, some tips that didn't make the cut, but they're also very important. I want to start by introducing our all-star statewide special education panel. We have, these are all my colleagues, Candice Gomez, who practices downstate in Long Island and other parts throughout the state, Kate Reed, and by the way, Kate and Candice are the co-leaders of the Schoeneck King School Law Group. So we're so lucky to have them here today with us. Kate's offices are in Syracuse, but she represents school districts and clients throughout the whole state. We're also here with Ann McGinnis, who's headquartered in Rochester, but also represents school districts throughout the state. And also Andrew Mark, who, like me, is headquartered in Buffalo, but also we represent schools throughout the state as well. So thank you so much. We're going to get into it today. You'll have the opportunity to ask questions or make comments in the chat. We'll do our best we can to get to your questions. We have a lot of material to cover, and we're going to go through these topics. And we want to make this for you, again, to help you fulfill your lofty legal requirements that we have in the special education world. All right, so let's get right to it. And also, you can't see her, but many thanks to Kathy Purdy, who is in our business development office, and she helps organize this event, and she's helping us with the slides. So Kathy, let's go to slide number 1. Okay, we're going to go to next slide. Well, we'll catch up. Oh, by the way, also, one little housekeeping thing before we get started. The slides and the recording will be emailed to everyone who registered. It's also going to be put on our website as well. So even if you if you registered and were unable to attend, you will be sent the materials as well. So, okay, so I have a slight delay with getting this slide number 1 up, but we can get into it. I'll tell you verbally what slide number 1 is. It's a very important one. It's okay. So tip number 1 is start identifying and preparing for novel circumstances where students with disabilities may need to participate in unique school-related activities. When I'm talking about unique, we're talking about extracurricular activities, senior class trips, sports activities, school dances. We all know that we have an obligation to accommodate students with disabilities, to enable them to participate in all activities, including extracurricular ones. And we find that the most challenging ones are the school trips, especially out of town school trips. And we obviously want to prevent last-minute scrambling to enable everyone to participate. So I want to open this one up to the panel as we dive deep into this issue.
So Jeff, I'll get us started just on one point that I think is often overlooked, and it may be a basic point, but it bears repeating, as you said, as we're entering the 24-25 school year. And that is that we have to recall that IDEA requires CSE to consider which extracurricular modifications and accommodations are necessary for students with disabilities. And that extracurricular piece is entrusted to the CSE for IDEA eligible students. The rules are a little more flexible when it comes to 504 students, and I'm curious about my colleagues' input on that as well. But that it's not required that the 504 related accommodations for extracurriculars be determined by any specific committee or group of people. But the extracurricular modification piece has to be considered for all students with disabilities. And like Jeff said, in our experience, a little bit of forethought about that, about the types of activities the student is going to want to participate in, how they can be accommodated, issues that might come up logistically, for instance, with traveling nurses, medical care that may be needed on field trips, and the school play or extracurricular athletics, etc. I know as a group we've talked a lot about nursing, so maybe that's what I'll punt back to my co-panelists here to talk a little bit about how you navigate situations where students need a nurse to be able to participate in a field trip or another extracurricular activity. How do we handle that, or what are some of the issues that come up legally with that?
Sure, I can share some information about that. A frequent call that we get is there's a school dance tonight and a student with diabetes is attending. Do we have to provide a nurse? Or the senior class is going on a trip to Washington, D.C., and one of the students has a seizure disorder. Do we have to provide a nurse? And the answer to that question is dependent on the student's needs, which, like Kate said, it's why it's a good idea to have the CSE or the 504 team convene to consider what those needs would be, hopefully with more time than it's happening tonight. But I understand that sometimes that happens, and we're working at the last minute with that kind of thing. SED has some guidance about specific situations for nursing and when students need nursing support, and it depends on their medical needs and how independent the student is around that. But the basics are, if a student does require a nurse to administer medication or to monitor a medical need, even if the medication is an emergency medication, then the district needs to provide that nurse for an extracurricular activity or anything that's really district sponsored to allow the student to be able to participate. If the student's parents volunteer to serve in that capacity, then that is sufficient. We can do that, but we can't require them to do that. And if they don't, then the district is on the hook for having to provide that nurse if the student needs that.
We often get questions to kind of spin off what Ann was saying. We often get questions about, well, maybe it's not the parent. What about, we get requests from parents for, well, I can't make it, but what about having a peer serve as the nurse, or what about having a paraprofessional serve as the nurse? We don't want you to ever get into doing that. The reason is because there's actually laws and regulations that govern the practice of nursing in New York State. And we certainly don't want any of you to be liable for the aiding and abetting of unlicensed nursing. The reason the parent can administer medication and medical care to a student is because that's a specific exemption under the state education law. Those people do not have to be licensed in order to administer medical care to their own child. That's not the case when you're talking about little Johnny's friend. That would be the unlicensed practice of nursing, or a paraprofessional who doesn't hold any medical certification or licensure. So I agree with Ann, when push comes to shove, if the only option is the parent, I think we would all agree we would rather that you have the parent be the chaperone or aide, so the student can participate. But ideally, you want to be meeting the student's medical need, which is a skilled medical professional for this type of stuff.
There are some medications that non-medical personnel can be trained to administer, like an EpiPen, but other medications such as Diastat for seizure disorders, they have to be administered by a licensed medical personnel. So that's why that SED guidance is very helpful, because it breaks that down and provides those guidelines for who can administer what. And then again, it also depends on the student's independence around administering medication.
Yeah, and so I think one of the key takeaways is it's complicated to get these accommodations done in new settings. So the advance notice, I mean, if you really want to be a 5-star district in this regard, if you could somehow build this into an annual review, an annual review, and actually ask, what do we got coming up for the next school year? And it's sometimes that'll clean up maybe 70, 80% of these. Something like, hey, we know the senior trip is next year, or we know that all 8th graders go here. Or you ask, what sports is Johnny going to play, or what activities? And again, usually if we have notice and time, we could get it done. But it's the last minute crunches where we always make the joke that we get the phone call and the kids are getting on the bus, it's too late. So a little planning goes a long way.
Yeah, and just so
absolutely.
I'm sorry, just so you all know,
Yeah.
it's not just nurses. So it could be an aide, it could be other things. Sorry, Candace, go ahead.
No, you're absolutely right, Anne. And with regard to preparation, some things, get missed if they're not thought about early, such as whether or not a child with the wheelchair may need an adapted bus in order to go on the trip, or if special seating is needed for certain students on the trip, either because of a physical need or some type of emotional or behavioral need. We know it can be difficult when you have 50, 100 students all traveling at the same time on a field trip. But just because we have a large number of students doesn't mean that we can then neglect the needs of any one particular student. We still have to be faithful to that 504 plan and IEP and make sure we're implementing it for each student to the best of our ability while they're on that trip.
Thanks. All right, well, let's go to slide number 2. And again, we're still working out some slide issues. Thank you for your patience with that. So the next slide, this is a simple one. It's called data, data, data. Remind your teachers and related service providers to review their annual IEP goals being implemented this year and collect baseline data for such goals to assist with determining whether goals should be revised. Develop goal data sheets to prepare for collecting data. Have teachers and service providers ensure that they have an IEP goal for their service, and if not, be sure to add a goal. IEP goals can be modified by amendment or by convening the CSC. So again, it's a fluid process. Goals, and it's kind of like words and music. The data and the goals go together, and this takes work. This is hard, but if you are diligent and your staff is able to be committed to tracking the data throughout the year, and then ultimately, if the light bulb really goes on, that'll help develop goals that are conducive to data collection, and they go hand in hand. And then suddenly, your goals will prompt you to get even better data. And so, a little test. Sometimes we're at a CSE meeting, and if we look over and we say, do we have any data supporting our belief that this is a great program? If the data isn't there, it's going to be a hard time defending the program, even though it might be appropriate. So I want to open to the panel on that note.
I think everybody that's on this call works with lawyers and hears us say every day of the week, if it's not in writing, it didn't happen. And I think the 5 of us that litigate impartial hearings on a regular basis know that that is no stronger the case anywhere than it is in special ed. Your data is key. And when push comes to shove, if there is a dispute, what has been documented in terms of progress, and specifically progress towards those goals and benchmarks, is going to be critical. And I think that Jeff's comments were focused on the academic progress piece. I want to just put a pitch in there also for behavior data. In my experience litigating impartial hearings that pertain to least restrictive environment or student behavior concerns, data is also going to be key there. Your ABC data, your data confirming implementation of behavior intervention plans, the modification of those behavior intervention plans to adapt to the needs of the child. Data is key in all regards, but in behavior, in addition to the academic modifications and progress as well.
Absolutely. That's so right, Kate. And, I think there is sometimes the temptation to do copying and pasting when it comes to IEPs, just because there's so many students that have annual reviews at the same time. but it's so important for the CSE to take the time to really make sure, excuse me, that each goal is individualized, that we're looking at the past data in order to create new goals for the future, and that we're tracking progress towards those goals. If we needed a student to have 60% proficiency in the previous year, and they've met that goal, we should make sure that now we're moving up to 80% proficiency, for example, or maybe creating a new goal. But one of the worst things that can happen is that an impartial hearing takes place and we see goals that either don't make sense or we see goals repeated year after year, and we really can't explain why we haven't done our part in order to make sure that the child is progressing at a reasonable rate. And just to kind of go back to something really fundamental, making sure that everyone who is working with that student has access to the IEP and has properly read the IEP is so important. Sometimes it can be missed that a teacher's aide or a one-to-one has not received a copy of the IEP. Having a checklist or some type of formal documentation at the beginning of each year so that we know exactly who has the IEP, we verify that they've read and understand it, can be very important. We don't want half of the year to go by and realize that someone who should have had access to that information really was just getting it through word of mouth and not through means that were as correct as they should be.
Just on that note, and again, boy, data is so important. One of the challenges we see in hearings, as Kate said, goals are always attacked. And a common attack on goals is that the baseline isn't included in the goal. Like, for instance, if it's a fluency goal, the goal will say by the end of the year, they'll read at 50 words a minute. But the challenge will be, it should say, will be increased from 30 words a minute to 50 words a minute. And they want that in the goal. Now, in a perfect world, that baseline will be in the goal. But if it's not in the goal, it should be in the PLEPS. It should be somewhere in the IEP and easy to find. And so, again, it takes work to get that baseline. And when you're developing, like every piece of data that's developed is going to be crucial to the process. And the time to do it is obviously at that annual review meeting. But then again, we talked about what if the goal is met halfway through the year? It's January and they got up to 50. Well, time to amend that goal and let's update it and so on. Don't wait until it's too late. Keep it a fluid process. Okay, Andrew, we're going to get you in here. Andrew's a.
No, I was just going to say, Ed, we're litigating a case right now where the goals are at issue, and one of the claims is that it's a reading case, and the reading goal doesn't say to increase the student's independent reading level. And there's case law, good case law on our side, saying that that's too general. It doesn't provide enough direction to the students' teachers. Of course, the overall goal is to increase the student's reading level, but how do you do that? You have to address the underlying needs, and in this case, it's decoding and fluency and those types of things. So, that's our position, and there's good case law to back that up. So I would just, add, we're getting into the weeds a little bit here, but make sure that the goals aren't too general and that they're addressing the underlying needs as well.
Yeah, it's like remember, like the spine of the IEP, the foundation is that, I call it the mini continuum: PLEPS, needs, goals, services. They should all match up perfectly. If you could do that, then you have a strong fundamental IEP. Okay, next slide. All right. The next slide, because we got up to 2, so hopefully we'll get up to 3 on the next one. The next slide is dealing with everybody's favorite topic, IEEs. So, IEEs. So the tip is as follows: if your district has a policy for independent educational evaluations with cost or distance limits. You should review your policy to ensure that any cost limits are consistent with the prevailing rates in your community and there are sufficient evaluators located within any distance limits. And obviously, if your district does not have a sufficiently detailed IE policy, you should adopt one. So again, I want to open this one up to the panel, but this is particularly important because if we do our due diligence with these components of the policy, we might be able to take some stands against unreasonable demands for IEEs.
But I think, Jeff, oh, go right ahead, Ann.
This becomes particularly important when parents are asking for IEEs with evaluators who maybe don't have the qualifications that we would expect for that particular evaluation, or whose fees are much higher than what we would typically see in our area, or who maybe is not even located in our area. So we can put together criteria around credentials, which have to match the credentials of our evaluators who are doing the same types of evaluations. We can put a criteria around fees, which should be based on the local geographic rate. And we can also put some criteria around the distance of the evaluator. We can't just outright deny an IEE request if a parent chooses an evaluator who does not comply with our criteria. There should be procedures within our policy or our regulation or our procedures around how to manage that when a parent asks for an IEE that does not comply. We would usually ask for the parent's justification for why their child's unique circumstances justifies obtaining that evaluation. And then from there, we should either grant the request or we should initiate due process to defend our criteria. And we've done that before where we've said, we agree that you can have the IEE, but you have to go to somebody who has the right credentials or whose fees are reasonable to do that. But again, sometimes initiating due process, or maybe always, the cost of that would likely outweigh the cost of just paying for the IEE in general, in total. And so that becomes a business decision for districts. When you have a particular evaluator who's maybe doing a lot of IEEs in your district, that might make more sense to take a stand than if it's a one-time situation. It really depends on the circumstances.
So I think that last point is a really great one just on the strategy, because that's a question that we get all the time, which is when does it make sense to fight an IEE versus just acquiescing? Because to Ann's point, the regulations in New York are clear that you don't have the option as a district of simply denying the IEE. You have to go to due process to defend either your criteria or to defend the underlying evaluation that you conducted that the parent is challenging. And it is a business decision. I think something that we've all done to fairly, good effect in the various areas that we work in around the state is that sometimes there can be advocates that push for particular types of evaluations repeatedly as well. So here in Onondaga County, we had an advocate that was pushing aggressively in pretty much every CSE meeting throughout the county for reading-related evaluation, reading IEEs essentially for every student. Every student was dyslexic. I think they would have probably said a ham sandwich was dyslexic. So we saw all these requests for IEEs involving the same evaluator coming out of the same advocacy group. And that was a situation where the district said, we need to send a message, because even though special ed proceedings are confidential, because we're seeing a repeat frequent flyer here with the evaluator and with the advocate who's making this request, in this situation, it makes sense to go to due process, defend our underlying evaluation, to send a strong message that we're not going to simply roll over every time we get one of these IEE requests. And we did that. We prevailed. They're straightforward hearings. They're not, those of you that have been involved in due process challenging placement decisions and unilateral placements and things like that know that those hearings can go on for days and days and days. The IEE ones tend to be a lot more streamlined. It's typically, just the evaluators that we're putting on the stand to explain the methods they used and to defend that process. So don't be scared off for that reason. It's not, it's certainly not as burdensome a due process procedure typically as your more complex hearings involving placement disputes.
Right. Yeah, so, the key piece, we see dust off those policies, those procedures. Sometimes the limits or the monetary values are dated. Maybe come up with a procedure every year, have someone in your office, maybe an admin, call the same people every year, say, what are your rates? Just checking, update your documentation so you're ready to roll. If you have an unreasonably high evaluation, you'll have data to show it. You don't want to be doing this data testing on the eve of the hearing.
I think
You want to do it before.
I think we've all been in the position, Jeff, where client sends us their cost containment criteria, and they also send us their list of sample evaluators that they provide to parents. And the sample evaluators in the schedule are charging more than the maximum fee amount approved by the district. Well, that's going to be a loser. There's no way we're going to be able to defend that cost limit if even the recommended evaluators in the region that the district's advising the parent to use charge more than the district's cost containment criteria. So I think some of our best special ed directors make a habit of calling the evaluators on that schedule regularly just to confirm that the rates are still commensurate with market standards. And those do have to be increased typically periodically to make sure that you're keeping up with market standards, because you're not going to be able to defend that containment criteria if you have not modernized those standards. So I think that's a great point, Jeff.
Yeah, and a couple of questions on this. Do you have some sample policies that you have seen and would recommend that you link for IEEs? Obviously, contact the attorney that you usually work with, and we can help either with samples or to review. I mean, the thing is, it's not automatically one size fits all because different districts have different practices, but we could certainly help in that regard. There's lots of samples and good language floating around. And then do charter and private schools also need to have an IEE policy? This is an offshoot of the CSE. So charter schools and private schools don't have CSEs. So they do not need to have an IEE policy. From a public schools perspective, it would be nice, but any thoughts on that to the panel?
Right, it's a CSE obligation, and the public school would have the CSE obligations in that situation.
I see a question in the chat also that's a great one, which is, do our sample evaluators and fees need to be BOE approved or simply in policy? I think that's a great question. So we know in New York State, by law, policy is the responsibility of the Board of Education. So if your policy has been board approved, if you have policy in your board manual, then that policy by definition is likely board approved. In my experience, I think there's a more flexible way to do that versus bringing your fee schedule back to the board every time it needs to change. Most districts have either a boilerplate policy or policy language embedded in the special ed section of their policy manuals that states that the superintendent or designee can develop administrative regulations to implement certain policies. So if you have your policy that generally sets forth the criteria for IEEs, you could then have an accompanying regulation that is delegated to the superintendent or designee to update as necessary. The board is ultimately responsible for the fiscal responsibility of the school district. So at the end of the day, your IEE expenses either should be budgeted or that fee schedule should be presented to the board for action. But in my opinion, it wouldn't have to be in a formal policy. I'd love to hear Candace's take on that as well. So a lot of the board governance work, Candace.
Yeah, Kate, I do think having those administrative regulations can be very helpful because the cost sheet, for example, will change from year to year. So for example, in year one, the cost of an evaluator may be $500. In year two, maybe it's $550, for example. We don't necessarily want to make those changes to the policy each year. It's okay if your district has it that way, as long as we remember to go back each year and take another look at it so that we don't fall behind on that cost schedule. But otherwise, having a bit more flexibility through those separate administrative regulations with the policy only stating that the superintendent will review and revise as necessary, could be helpful so that we don't need new board approval each time a particular cost for an evaluator changes in our area.
Yeah, it's interesting that I'm sure all five of us, I've experienced this many times. We're reviewing the policy with the client and it cross-references an administrative regulation. It says the district shall develop an administrative regulation for this policy, and there is no regulation. And so, which kind of goes back to, like, if you don't have a regulation or something concrete or a policy, that something to put on your to-do list for the upcoming year or in advance of the year. Okay, let's go to the next slide. Tip number 4, which is everybody's favorite topic. All right, FAPE 22. Start identifying students with disabilities who will be turning 21 during the upcoming school year to determine the extent to which they may be interested in remaining in school until their 22nd birthday, and perhaps longer if permitted in your district. Advance notice will make it easier to make appropriate arrangements. So we all know this was a huge development about a year or two ago, where under some case law, the entitlement to FAPE in New York, at least for now, extended from the conclusion of the school year in which the student turns 21 until the 22nd birthday. Not all parents want this option. For those who do want this option, it's at times very difficult to program for these students. So this is and also there's monetary issues. When this first came on the scene, it was out of the blue and it caused a lot of issues, monetary, practical, and so on. Now we have the luxury of planning for this in advance, but it's something that we need to build into our ecosystem of keeping our eye out for this. So our tip is just internally track these kids and start maybe discussing with the parent, having internal discussions about options so that you're not scrambling at the last minute.
Yeah, Jeff, that's so important what you've said. And I think that this is still a point of concern and confusion for many of our school districts. So in terms of how we got to this point, I think it probably is worth just spending a minute or so talking about the formal opinion that was issued by the New York State Education Department and how that grew out of the Connecticut case. So in July of 2023, the New York State Education Department issued a formal opinion of counsel, which advised school districts to provide special education services to some students with disabilities through the age of 22. And of course, that additional year would be likely to have an impact on school budgets that previously were only going to provide services through the age of 21. Now, this opinion of counsel in New York State came out of the U.S. Second Circuit Court of Appeals case in Connecticut that held that Connecticut needed to make FAPE available until the age of 22 for students with disabilities who had not yet received a high school diploma. New York pretty much piggybacked on the Connecticut decision and said, it makes sense in Connecticut, it makes sense in New York. We want school districts to go ahead and implement it. That has been challenged, but at this point, in order to be the most cautious and to not later on have to clean up a FAPE situation gone wrong, for the most part, our districts are implementing this until the age of 22, even those who may not believe that this really should be the new requirements, and there's certainly room for argument on both sides of that. So we are not saying that by implementing this until the age of 22 or beyond 22 is absolutely the right legal approach, but it is the safest legal approach at this point in time until the litigation is finished. And when I say possibly beyond the 22nd birthday, that comes from, again, the Office of Counsel Opinions, stating that if that student's 22nd birthday falls at any point during the school year, then even though school districts may not be strictly required to, they are recommending that districts provide such services through the end of the school year in which the student turns 22, or upon that student's receipt of a high school diploma, whichever one of those circumstances comes first.
An interesting issue that's come up for me, and I'm curious if any of my colleagues have started seeing claims like this as well. It's kind of an offshoot of this development. So the Office of Counsel Opinion that Candace referenced followed the Court of Appeals decision last summer, in the summer of 2023. I have started seeing a few claims trickling in for students who turned 21 prior to that Office of Counsel Opinion being issued. And the position that their attorneys are taking is that essentially they're entitled to ongoing services, even though they technically aged out before the law was clarified. The points that these parents' attorneys are making is that it really wasn't a change in the law. It was just a clarification of existing law. And Jeff's nodding. I think he agrees with that. And then the other point they're making is under our traditional case law under IDEA, parents could always sue for compensatory education, meaning services past age out. But the standard is higher than for compensatory education before a student has aged out. You have to meet the standard of a gross, meaning a substantial denial of FAPE. Well, I don't know how that's going to work out, because potentially cutting a student's eligibility short by 1 year very well could be construed as a gross denial of FAPE. So all to say, that's been an interesting twist for me to see the claims that are coming in that pertain to kids that we haven't even thought about since last summer, because they aged out last summer. But under this new ruling, they would have been entitled to services through age 22. So I have a couple of due process complaints pending with that fact pattern, and curious if any of you have encountered that as well and how you're handling them.
I have not seen that claim, but as you can see from me nodding, so that makes sense that technically this was the rule all along. But what's really interesting to me is they'll run into the 2-year statute of limitations. However, maybe they'll argue that it should be extended because did the district mislead them into thinking it was 21? So, and those statute of limitations are tricky. Boy, oh boy, that's really, I did not even think about that, but that's really interesting.
It'll be interesting to see how they shake out. We are, most claims involving services past age 21 traditionally were hard for the parent. They were easier for the district to defend. So I expect we'll still have that case law in our favor. But now that the state has said that those kids technically had eligibility for an additional year, I could see those cases going against districts as well. So I think that's in the category of this drives everybody crazy on webinars, but I'll say call your bond attorney if you have that specific fact pattern, because we'll want to talk through your risk tolerance, your business, choices, and what you want to do with those claims. And a lot of that will depend on how many you're defending.
So we had a question come up on this. What is the best approach when an out-of-district placement will not keep a student beyond the end of the school year after their 21st birthday and no other appropriate placements can be found? And we're seeing this happen. We're especially seeing this happen in situations where the students age out mid-year and the out-of-district placements are maybe saying, well, we have so many students on wait lists, we can't commit to a student who's only going to be here for a short period of time in the year. And so they don't agree to keep the student. That might be a reason to consider the full year for a student if that can help with a placement. I'm not saying automatic in that situation, but that might be a reason to consider allowing the student to end through the end of that school year in which they turn 22. But ultimately, because this right to a FAPE continues until the student turns 22, the district is on the hook for figuring out how to provide that free appropriate public education. And that's hard to do when we don't have a placement. So districts have become creative around that. I've seen districts put together some transition services with students and some opportunities to get out into the community with some supervised transition support, providing related services or tutoring, very similar to what we do when we can't find a placement for other school age students. And we're searching where we have to try to find a way to put a program together to still address that student's needs. In all likelihood, we're probably unlikely to find another out-of-district placement to accept the student for just a period of a few short months, but we should try to see if that is an option as well.
And I think, Anne, I like your point. In a lot of ways, this is the exact same fact pattern we deal with every day of the week. You know, when a BOCES says we can no longer accept this student, or you know, an 853 school says, sorry, the student doesn't meet our needs, we're ejecting them. We all know that that's not supposed to happen under the regulations, but it does. And I think the point here is, because that eligibility continues until age 22, you're equally on the hook, regardless of the practical difficulty with that situation. But I agree with Anne. I think you're unfortunately on the hook, and the business piece of it might mean that in order to secure those services for the period of eligibility, you may end up supplying services for longer than that in order to secure a placement. So that's a really great question, though, and we have been seeing issues with that. The flip side of it is that I've also seen the out of district placements insisting on more service as well. We've seen that where once the age 22 ruling came down, a lot of the 853 schools and the CRPs reached out to the districts to basically say, this is a high needs kid. Are you going to approve until the end of the 22nd year? Let's keep them here. So that's the flip side as well. We've been seeing some of the schools pushing for services exceeding the district's you know, legal obligation in many ways, because again, it's only until the 22nd birthday, not necessarily to the end of the school year in which the student turns 22. I think those requests put the district in a difficult position, because if the facility that is extremely familiar with the student and who's been tending to their needs for, in some instances, several years, says, oh, geez, this kid would really benefit from additional instruction and, you know, et cetera, that's going to be hard to defend. So we're seeing the flip side too of the question that turned up in the chat.
All right. Well, let's go on to the next slide. This is a very important slide.
They're all very important slides.
Yes.
Yeah.
This is, you got it. Review your district's response to intervention procedures to ensure that they're sufficiently detailed and meeting the needs of your population. Particular emphasis should be on reading interventions for kids in grades kindergarten through 4. Make sure your tiers, tier 2 and 3, are tight and working and successful, and you're setting it up with great data collection and monitoring. So this is what it comes down to. For those of you who've been doing this a long time, like me, and like all of us on the panel, we remember the severe discrepancy standard for learning disability. And that was highly criticized, and it was essentially replaced by response to intervention, but only for kids in kindergarten through 4th grade with respect to reading. And when this came out, it was a big deal, and everybody was focusing on their RTI procedures. And we're seeing, with the passage of time, there might be less focus on this process. And it's extraordinarily important, even though it's technically not special education. We're seeing whether it's cuts or less focus. Make sure, obviously, you have 3 tiers. Tier 1 is the curriculum. So it's tier 2 and tier 3. Make sure you have some structure in these tiers so that a student can go through the process, and we can rule out whether or not it's a need for extra instruction or whether it's a learning disability in reading. And you know, make sure it's set up for progress monitoring, make sure great data is collected, so that if we don't refer a student to the CSE, we actually have data showing we didn't need to because the RTI was successful. And you want to have recommended weeks or months in each grouping. You want to have great data collection. And we're just seeing that with the passage of time, this is just being neglected somewhat, and make sure that you're putting the right focus on this. And also make sure your RTI procedures are working. If every kid is just going through these tiers with no success and they're all going to the CSE, it might be a sign that the curriculum or approach you're using is not a good one. And so I want to open this up to the panel, but again, in this day of reading litigation, which is booming, this is extraordinarily important.
Yeah, that's so correct, Jeff. And I think this applies not only to RTI, but also to MTSS, right? Which districts are using. So one of the, I think, most important takeaways that I hope to share regarding this is that a child does not need to experience each tier of RTI or MCSS and fail at each tier prior to being referred for special education services. The Federal Office of Special Education Programs, OSEP, OSEP, they've been very clear that MCSS and RTI may not be used to delay referral, evaluation, or the provision of special education and related services. So in other words, we don't need to have a student who obviously needs special education go to tier 1, spend a few months there, fail at it. Then we move to tier 2. Of course, they don't do well. They fail at it, move to tier 3. We're not going to put a Band-Aid on something that is obviously an open wound and needs much more intense attention and treatment. So that would be my note of caution for districts. The tiers are great, and to the extent we can reasonably work through the tiers, we should be doing that. But when we have a student that really is in need, we should not be languishing at any one tier and making our way slowly up that ladder when it's very clear that we need to go ahead, make the referral, and get them the help that they need.
The way I can absolutely reiterate everything that Candace just said. I agree entirely. And I actually I was burned in an impartial hearing quite a few years ago for precisely this point. The district was doing gen ed interventions that really, although they were gen ed in name, they were really special education interventions. And that's ultimately what the state review officer said. They said, your child find obligation was triggered by the fact that the student was in an AIS group for 4 years and was not making adequate progress. So you certainly do not want to plop kids in AIS and RTI and keep them there. That persistent need for those interventions would indicate a child find concerned and a need to refer. The specific situation that I had involved a special class that the district was utilizing as a general education intervention. They were calling it support lab. But we had testimony about what happened in that support lab, and the SRO ultimately ended up saying that support lab was basically a resource room in disguise. It was offering specialized instruction. It was offering differentiated instruction. It was not simply providing makeup or study hall. There was direct interventions being used. And the parent cleverly relied on that fact as a basis to say, you've already conceded my kid needs special ed. It was an initial eligibility challenge. And they said, you basically conceded that because the support lab that you're using as an AIS intervention is really in essence special education. So I think be mindful of those types of sneaky claims as well. You don't want to keep people parked in AIS or RTI indefinitely, to Candace's point.
Hey, Jeff, if I'll just jump in. So there is a good guidance document from New York. It's relatively old, and that's from 2010, but it's very thorough and comprehensive and gives great guidance as to how many data points should be collected to monitor progress, guidelines with respect to how long students should be in certain tiers before moving on. I'm in the weeds in this document right now because we've got a case about child find that involves reading. And one of the questions that came up during the hearing on cross-examination was regarding how many, what are the district's guidelines with respect to how long a student should be in tier 2 versus moving on to tier 3, and unfortunately there are none. So that would kind of piggybacking off what everybody else has been saying, but when you go back and you look at your own RTI procedures, make sure that there are guidelines with respect to those points at which students should be moving out or moving down or moving back up, how many data points are being collected. And the guidance is very clear that, there's the progress monitoring should be occurring very frequently. So this is just a shout out to that guidance document from 2010, guidance from New York school districts, response to intervention. I'd recommend consulting that again.
Yeah, so just again, go back to make sure if you have a good procedure, it would have recommended like maximum time frames, whether it's 10 to 20 weeks or so on. There's lots of different recommendations. You should have the time frames in your procedure. and along with group size for the tiers and frequency and duration, it's going to really pay off in the long run. Okay, let's go to another important one, tip number 6. This is new. This is new. Physical restraints. There is now mandatory. There are 2 types of mandatory training with respect to physical restraints. So make sure that you're arranging for this training. There's 2 types. The first type is for all staff. This is regardless of whether you're likely to use a physical restraint or not. All staff are required to receive annual training on policies and procedures for the use of timeout and physical restraint, the evidence-based positive proactive strategies and crisis intervention and prevention procedures and de-escalation techniques. So let's hold that thought, but this is for all staff. And then in addition, any staff who may need to implement timeout or physical restraint are required to receive annual evidence-based training in safe and effective, developmentally appropriate timeout and physical restraint procedures. This is the way I read this is, if it's anticipated that you're a teacher who's likely to use a physical restraint on a student, probably an 811 teacher, let's say, you need to be trained on how to administer a restraint with CPI or TCI, or whatever it's called. That's for the teachers who we think will need to actually use a restraint. Everyone else has to receive annual training, more of a legal training. It's not clear exactly what this is on what the rules are for timeout and physical restraint. A reminder that certain strategies could be used and that there are procedures and de-escalation techniques. But that training is not CPI or TCI. That's more of a legal training. And some schools are just incorporating the first training in there, like Welcome Back, Welcome Back Day or Superintendent Conference Day. So there's 2 different training requirements for 2 sets of categories. So I'm gonna release this to the panel.
Sure, this is new as of last year. Their new regulations came out, I believe, last summer in 2023. And it now requires districts to have policies on this. Before, we only needed, for example, a timeout policy if we use timeout. Now we have to have these policies. So be sure that your policies have been updated. A lot of districts are still getting to that. And this is a popular topic right now for state ed and for the Federal Department of Education. So look into those. And the training requirements, the mandatory training for everybody is also a new requirement, although we always had to train people if they were going to engage in physical interventions. It's also important to make sure that you have documentation and forms ready to go, to be sure that parents are notified the same day that these interventions are used, that the documents are being filled out the correct way. And the regulations also require that we share those documents with the parents. And the regulations have specific requirements that have to go into the forms that we fill out and what we document, which includes specifying the staff who were involved and any injuries that were sustained and that kind of thing. So it is important to be sure as we're heading into the new school year that all of that has been updated and that staff understand their responsibilities.
Right, and beginning this school year, we're going to have reporting requirements as well. So it's critical that you have those forms in place that you can document.
Right, because part of the training is to tell the staff that if they use a timeout or physical restraint, they need to fill out a form, and that form will be used at the end of the year when they submit their annual report. So this is all related. So
I think one of the
sure.
areas too that you should consider just tightening up is if you are a district that utilizes timeout, make sure and consider consulting with us regarding whether that timeout room and that space that's been designated for timeout is truly compliant with the regulation. I had an audit finding for one of my districts that was based solely on the fact that the timeout room was being utilized for children in the 5 to 6-year-old range, and the handle for the door was up very, very high on the door. So a little 5 or 6-year-old kiddo was not going to be able to reach that door. One of the requirements under the Part 200 regulations is that if you are going to use timeout, a student can never be confined in a timeout room. They have to be able to exit the room on their own volition. So as a result, you do not want to be in a situation where just the physical layout of the room makes that impossible. That will result in an audit finding, and it potentially can harm you in an impartial hearing if that issue comes up as well. So I've done, as most of us probably have, inspections of timeout rooms. We've checklists developed for that if that would be helpful for you as well to do it yourself. But definitely if you're utilizing timeout for the IEP interventions of any students in your district, make sure that room is technically compliant, and make sure that you are aware as a special ed director of how the buildings are using informal forms of timeout as well. I know, Anne, you've spoken about this at prior panels I've been on with you as well, but there's a distinction between, for instance, a sensory room, which is permissible, versus a cool down space. I've heard lots of terminology used to describe what by regulation really is a timeout situation. So be mindful of those things too. As administrators, you're likely not, in the weeds of how those things are being used, but be aware of how your buildings may be informally using timeout in such a way that they really should be coming under these regulations as well.
Okay, let's go to the next tip. Another important tip. I'll put we have it nicely written in this tip, but I want to put it in plain English. Avoid this situation, which is we get a hearing request. It says Johnny's been suspended and removed 30 times and never got a manifestation meeting. And the director of special education sees this and scratching his head or her head saying, I have no idea what this is about. And then we find out at the building level, the kid was being informally suspended or sent home or call to the parent asking to pick up. And we essentially violated the rules for pattern and manifestation determination meetings. So this tip is meet with your building level administrators and just review the pattern and manifestation process. Crucial here is coming up with a procedure to track the number of times a student is suspended or removed throughout the school year so that pattern determinations are timely and appropriately conducted and manifestation meetings are held when legally required. Don't skip over the pattern part. Schools are getting better at doing pattern determinations. A lot of times they're just acting, they skip it and they'll say, well, we're over 10, we're going to have a manifestation. It might not be connected by a pattern. You don't know. Staff should be reminded that these rules apply to students with IEPs and Section 504 students and students suspected of having a disability. So a quick meeting with your building level staff who might not usually live in the world of special ed like special administrators do, helping them issue spot and streamlining your processes so that you're ready for these removals and you're following all these rules, and we could avoid this type of litigation, which again, this is a big focus of special education litigation over the last few years. And now I'll open it up to the panel.
Yeah, that's correct, Jeff. And I know that we have some seasoned special education veterans on this call, but we also have some individuals who work in the school setting who may not be working on special ed issues full time. So for that purpose, I just want to kind of give a quick overview of why this pattern determination situation is so important, as Jeff has been laying it out. When there's a pattern of non-consecutive short-term suspension, so for example, we have a student who has been suspended for 1 school day, then maybe the following month they're suspended for 2 school days. So it may not ever rise to the level of a superintendent's hearing or something that we would normally consider a serious situation, for example, but all of those separate little instances will then accumulate possibly to removals from that regular placement totaling more than 10 school days in a school year. And when that happens, that is deemed to be a disciplinary change in placement for students with disabilities, which would then trigger the need to have a manifestation determination review. So that's kind of, for those who are not full-time dedicated to special ed, why this is so important. We need to make sure that even though they may seem like kind of one-off situations, a one-day suspension here, a two-day suspension there, that we're not removing students for periods of time that are extended without then going back, looking at their IEP, and really doing a thorough review of what's happening here. Is the student just misbehaving and these are not connected and we'll move forward in that way? Or is there something that we're missing in terms of the services that we're providing to this student that could help to avoid removals from the classroom? Maybe something needs to be adjusted in their IEP. They need a one-to-one aid. Maybe they need time to kind of walk around the building when they get anxious. Maybe there is some other procedure or service that we could put in the IEP, which would prevent them from being removed from the classroom for future suspension. So that really is the purpose of us doing these manifestations, to find out whether there's a connection between that student's disability and the fact that they are being suspended.
And I think there's another kind of frequent flyer issues that come up in connection with manifestation determinations that I want to hit on. And again, some of these may be obvious to the veterans on the call, but whenever we get an audience with this many special ed people, we always want to make sure our takeaway points are well heard. One of the things that has come up a lot in the CEQA field audits that I've been involved in and seen is the issue regarding convening CSE for students where an MDR is not found. That's another area where I think there's often a lack of compliance with the regulations. The Part 201 regulations require that even in the event that a nexus is not found and therefore that you can suspend consistent with a non-disabled student, you're still required as a district at that time to convene CSE and determine what services the student requires to receive a free appropriate public education during the course of the suspension. And I understood, I actually learned this from Anne, that apparently the state takes the position that the 5-day notice for that CSE essentially gets collapsed with your MDR notice period. So you're not required to comply with the 5-day notice requirement for a CSE if you're doing it in connection with an MDR. At least that's the position of CEQA. So I think that's an important reminder. The one that I think is the most commonly misunderstood rule for MDR, and it's not the special ed people that screw it up, it's the buildings in my experience, but there seems to be a misconception that folks learn in administrative school that the 10 days reset. And that is not accurate. Every day above 10 days constitutes a disciplinary change of placement if those suspensions are related. And that's why it's so important to do that pattern analysis so you're not missing days that should be considered as part of that MDR process.
Yeah, it's funny, Kate, we did a presentation a few years ago about top 10 myths in special education law, and that was the #1 myth.
Number one myth.
Once you get it resets.
I always say you don't pass go, you do not collect $200. We're not, there's no new 10 days. Those are your 10 free days and then they're done. So that's something that, again, I think the special ed folks know because you all interact with CEQA and you know that's a hot audit topic for them. But sometimes that gets missed at the building level. I find principals routinely misunderstand.
Jeff, just real quick to add, because I think this comes up from time to time too. When you're doing the MDR meeting, you're not just limited to assessing the classification of the student, to the extent there's other issues or documented issues like ADHD and things like that. I think we have an obligation to rule, to consider those diagnoses as well, because we've been on the other ends of those hearing requests. And thank goodness we had information to show that, or records to show that we did consider those. So that's not the only relevant piece, the classification on the IEP.
Okay. All right, let's go to number 8. We're hitting the home stretch. This is a quick one. Ensure that all staff members understand their IEP implementation responsibilities and have access to their IEPs, Section 504 plans, and behavior intervention plans before the start of the school year. And if that's not enough, make sure you have procedures in place so your substitutes are also familiar with that information. Document all of this. Yes, the substitutes are not exempt from these responsibilities. Make sure everybody knows what they have to do. This is low-hanging fruit. And the defense of I wasn't aware what was in the IEP, while it might explain the actions or inactions of the staff member, it's still the district's responsibility to make this happen. So again, low-hanging fruit, start of the school year, now's the time to make sure everybody knows what they have to do for the upcoming school year. I'm gonna open this up.
Yeah, this is
So
Vic.
I get the
Go ahead.
question a lot. Are we able to share information with substitutes that our student education records due to confidentiality concerns? And the answer to that is yes, because they would be considered a school official with a legitimate educational interest under FERPA. So it is permissible to share student information with substitute teachers when those substitute teachers have that legitimate educational interest in knowing that. And any kind of behavior intervention plan or IEP or Section 504 plan that they would be responsible to implement would fall under that legitimate educational interest. And from a practical perspective, this is difficult to do, especially at the secondary level where you might have substitute teachers covering multiple classes in a day. So it's important that every school building has a procedure in place for how they'll ensure that substitute teachers have access to these documents and understand what their responsibilities are. Maybe having a folder for each teacher with these documents in it in a secure place in the main office. And then also a contact person or more than one contact person for the substitute to connect with in the morning or throughout the day if they have any questions about that is important. This comes up at hearings. It comes up a lot at manifestation determination reviews, because one of the questions that we have to answer at manifestation was the misconduct a direct result of the district's failure to implement the IEP? And if you have a substitute teacher there and the student has a behavior intervention plan and the substitute doesn't know about that, then it could be difficult to say that the misconduct was not a result of the failure to implement the IEP, because that would include the BIP as well.
Yeah, this also comes up in OCR cases fairly frequently. So, we could get hit with due process complaints. We could also get hit with complaints to the Office for Civil Rights. And if any of you have been through that before, you get a very long list of, data and requests for data and information. And frequently depends on, what the allegations are. But, Ann and I are, recently had one involving accommodations not being implemented in every classroom. And part of what occurred was this substitute issue. You can read through OCR decisions, which I'm sure you all, that's on your list of things to do this afternoon, is to read through OCR decisions. But you can find, OCR will go through with a fine-tooth comb to see wherever they can ding you. And you can do everything almost all substantively right, but if they find that, it's a big red flag when they see that somebody did not even realize that the student had a 504 IEP. So it's critical that you document it, have a sign-in sheet, something like that, so that you can produce that if you're ever questioned about it.
We have a couple of good questions on this. One is, do Sentry/safety staff need to read IEPs? Is that only relevant for students who are there more likely to interact with them? We get this question. I actually had a hearing issue where a student had a behavior plan involving how to support the student in the hallway, and the security guard did not know about that, and they did not support the student in that way in the hallway. And the attorney raised that was an implementation issue. So yes, if there is a specific situation where a security guard would need to implement a behavior plan or something on the IEP, they should know about that. They don't need to automatically know about every student. Most students probably will not have needs in the hallway or with security in some way, but if they do, especially if it's on their behavior plan, we should let those individuals know about those responsibilities.
And to the earlier point that you made, Anne, if you don't do that, in addition to the litigation risks that Andrew was talking about, the other more basic risk is that you're going to have to find a nexus if the student engages in misbehavior in that situation, because you will not be able to establish that the IEP was followed. There would be a direct connection there between the failure to implement the IEP in that interaction and the student's misbehavior. So that would be a basis for finding that the student's misbehavior was a nexus, if the security person that they were interacting with was not aware of the behavior interventions that were approved by CSE for that student.
We have another
I'm
go ahead.
sorry. And I know we're talking about how important it is for the IEP within the realm of discipline, but remember, this comes up with medical related issues too. If there's medical related issues in an IEP or a 504 plan, but diabetic student seizure disorder, like what do you do in those situations? And usually those are some pretty tight protocols that if a staff doesn't know about, it could have a bad outcome. So this is just crucial on so many levels. Sorry, Ann, I know you had another question in there.
Yeah, the other question was, do subs need the actual IEP or can they have a cheat sheet? What do you guys think about that?
I mean, I think IEPs are replete with very sensitive information. So I understand where this concern is coming from, but I think from a mitigating exposure for implementation concerns, really, I guess my concern would be who's picking and choosing what's going on the cheat sheet, what is selected as what, the sub needs to know. I could see problems with that. It makes me a little bit nervous. I understand where the concern's coming from and why there's a desire to minimize all the information that's being supplied. It's kind of like those reports that go to the board for approval. They do not contain all the PLEPs and the description of evaluation results and all of that. And arguably, a substitute doesn't need information about the student's evaluation results and PLEPs and everything else to implement the provisions in that IEP. But I would just err on the side of making sure they have the information that is relevant to what they're being asked to implement. And for a substitute teacher, that's going to be a lot of the IEP in all seriousness. So I have some concern about that. That's not really an answer as much as me just spitfiring here. What do you think, Jeff and Candace?
I think one way to do it is if there is concern, I believe, and Andrew, if you could define in your directory information in your annual notification under FERPA, you could include a substitute teacher under district personnel. I think that will clean up some of this.
Yeah, and in terms of providing the summary as opposed to the entire IEP, I do agree with you, Kate, that having the IEP in its complete form is the better way. We certainly don't want to miss anything important that could be in there. And while the substitute is a substitute, they're going to be a school official that is perfectly authorized to view the information and bound by all of the same FERPA requirements as any other school official. To the extent that IEPs are being summarized in order to try to make the information more digestible for a substitute that has just walked in the door and may not have time to read a 10-page IEP, I think rather than summarizing, I would prefer something like highlighting maybe some of the most important factors that they should know and have that jump out at them immediately. But I do think they should be provided with the IEP in its entirety so that after they get through those highlighted portions, they still have access to and they're expected to read the rest of the information. Maybe they can't do it right at the start of the school day, minute 1, but they'll have it all available to them to read and to understand as they move through the process of educating the students.
Yeah, I agree. So from a practical standpoint, having been a teacher and prior to that, having been a substitute teacher, I think, it's probably great to have the IEP in its full self, but I really like that idea of having like highlight the important ones. And I think from a practical standpoint, you really want to highlight, specific accommodations that need to be implemented, like use of a weighted pencil, for example. I know Ann's going to laugh at that one, but any other accommodations that we could be easy to lose sight of, like if they need certain access to headphones or something like that. Those are accommodations that can be easily implemented by a substitute. Otherwise, from a practical standpoint, to the like, if a kid needs to be pulled out for a related service, highlighting the schedule, something like that. If we're talking about very little kids, very oftentimes those teachers will come to the classroom directly to pull those kids out. But those are the sort of, I think, practical considerations to keep in mind.
Okay, well, we've got 12 minutes and 2 more tips, and we're right on schedule. So let's get to number 9. Number 9 is, and this is such an important slide. There's actually 2 slides on this one, but basically, this is a short-term and a long-term tip. It's review the current capabilities of your district's special education teachers and literacy reading specialists to determine the extent to which they're trained to use multiple methodologies during reading instruction. So take an inventory of your people. Let's go to the next. Let's go to the next slide on this because it's the same point. Background, a student with a disability is almost never entitled to a specific teaching methodology to receive a FAPE. However, if a student is not making sufficient progress under the district's reading program or methodology, the use of a different program or methodology could help the student's needs. Now, look, there are other options available. You could provide your current reading program in a smaller group setting, or for a greater frequency, or for a greater duration. And that's usually our fallback argument is, hey, we're not legally required to provide a specific methodology. We can go the frequency, duration, class size route. But we find, again, in this world of tremendous reading litigation in special education, the districts that have staff members trained in multiple methodologies actually, well, one, they do a better job meeting their kids' needs, and they have some flexibility when conflict arises, where rather than saying we only do one methodology here. Again, this is contrary to what we say often, which is, remember, we're never obligated, or almost never, to put a specific methodology in an IEP. But again, we're seeing a vast range of expertise among school districts on what they can teach and what they know about. Some schools have trained every reading teacher in multiple methodologies, and some haven't. And we see this as a great place to invest your resources, because this is on the pre-referral and the CSE world. It makes our job a lot easier when we have multiple programs that we could possibly dip into. And I want to kind of open this up to everybody.
Yeah, my starting point on this, Jeff, always is, and I feel like this is one of these things where we all may have trained all of you too well on this point, because it's not uncommon that I will hear CSE chairs say, well, we don't specify IEPs on we don't specify methodology on IEPs, or methodology is within our discretion. All of that's correct. That's what the case law says. However, my response to you always, if that's what the answer is always going to be, okay, but you have to be doing something, right? You have to be doing something that is evidence-based, that has a research basis, and that is most importantly, either proven to have worked for this child based on their past progress, or if it's a new child that's getting the service for the first time, you have an evidentiary basis to understand that this is going to be successful for this student based on their specific type of disability. So, the answer to, must we have an Orton Gillingham trained trainer, for instance, on site? Answer, no. However, if you have a student with a systemic issues with, and dyslexia and other issues with decoding and all of that, you need to have a reading methodology that is designed to address those concerns. And you need to track progress towards it. So it's not enough to simply say, well, our teachers use an eclectic sort of approach. We're always going to fare better, to Jeff's point, if we can say, okay, we don't approve of OG, for instance, but here is our evidence-based alternative that we do utilize, or several alternatives that we utilize to meet the needs of children.
I always say that the goals drive the instruction. And so maybe the conversation is less about the methodology and more about what are the areas of need that the student has related to their disability. And if we're talking about reading, for example, what are the areas of need in reading, breaking that down, like we said earlier, into specifics. Is it fluency? Is it decoding? Is it comprehension? And then having very specific measurable goals to address those needs. And then from there, the teacher has the authority to choose the methodology to address those goals. But if we have data demonstrating that the student is making meaningful progress and that the student is mastering the goals at the end of the year, that's evidence that the IEP was appropriate, and wouldn't necessarily require that we include that methodology on there.
Right. Yeah, I think those are it's the ones where that when they hit the wall, right? Like when they get no progress, and when we go through, it doesn't happen that often, but you'll get to a point where we're doing one-to-one in a small setting. Maybe they're in RTI many years and they're nowhere. They're not making enough progress. It's like the emergency. It's the emergency situation where there's nothing else they could do internally. What do? And that's where this investment. And again, hopefully your district never has that situation. But those are the ones where they give us the most challenge. But again, we always say, at least myself personally, it's invest in reading. It's just so important. And again, this interesting. Reading is its second tip because it sort of dovetails into the RTI. Does anyone have anything else they'd like to add on reading before we go to tip number 10? All right. Tip number 10 is check. This is, again, in the context of we're getting ready for the upcoming school year. As a special ed administrator, take a walk and say hello to your school nurses and see, are they aware of anything? Any students' disability-related needs have changed. Some parents like to share information directly with school nurses as opposed to with the teacher or the administrator. If a student's needs have changed, the district may need to amend the existing IEP or 504 plan. For students without an IEP or 504 plan, we may need a new IEP or 504 plan. Let's just go to the next slide for a second. So kind of on that note, the existence of a healthcare plan does not override the district's child fund obligations. And when considering whether a student is eligible for an IEP or 504 plan, the district should view the student as if the healthcare plan is not being implemented. That's what Congress put in the ADA Amendments Act. So basically, check with your nurses to see if they have new information. You'd be surprised what you'd find out. You don't want to find out too late. You don't want to find out that there's a new disability or a change or something like that. And again, sometimes nurses are protective of their jurisdiction and they think they've got it covered, and they probably do, but their knowledge may be transferred to us because we're all part of the district. And if they've got new information, we need to act on that at the CSE or 504 level.
And I think the place, probably you guys have had the same experience, but in my experience, the place where I see this come up the most frequently is for the truly health-related disabilities, which I think there's still, like to the point of the slide, there's still a misconception in a lot of districts that those types of disabilities, if there's no learning nexus, can be served solely through an individualized health plan. And the guidance from OCR is contrary to that. It states that because that disability qualifies as a 504 related disability, you're still obligated to serve that student through the parameters of Section 504, which requires notice, procedural safeguards, consent, periodic reevaluation, convening a multidisciplinary team, and all the other requirements and the procedural pieces that go along with 504. So when I say truly health-related conditions, what I mean is the kids who just have asthma, for instance, or diabetes, or a bee sting allergy, things like that, I think there's still a tendency in a lot of districts to say, well, let's just serve those students through the health office without an understanding of the overlapping 504 obligations.
Okay. Any other thoughts, comments from the panel on this before we go to the honorable mentions?
There was recently some state guidance issued about the entitlement of students with severe food allergies with having 504 plans, and we will cover that in detail in our fall conference. So we hope that you can join us for that.
Yeah, but again, that's a great example of a parent calling the nurse saying, hey, Johnny has X allergy. And the nurse says, okay, here's what we're going to do. We're going to do great stuff and blah, 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 blah. And the nurse may have it covered, but that probably is eligible for a 504 plan. And if the connection isn't put in there, then we're going to have a problem because we're denying the parent all the procedural rights. Okay, got 2 minutes left. Honorable mention, these two did not make the cut, but they're worthy of mention as we prepare for the upcoming school year, this is a big one. Review your district's home instruction procedures to ensure that students receiving home instruction based on a temporary disability should be referred to the CSE after 6 months, because at that point, the disability will no longer be deemed temporary. This is something, again, this is all about remember we said the nurse connecting with the special ed office? This is whomever is running home instruction, gen ed home instruction. Sometimes it's the principal, sometimes it's the nurse's office. It's okay to grant home instruction for a temporary disability for a short term, but if this is going on for more than 6 months, which is temporary, that's a temporary line in the sand under federal law, then those kids should be referred to the CSE. So you don't want to have kids on home instruction for years without being referred to the CSE. Now, if you refer them to the CSE and the parent doesn't consent to an evaluation, we're off the hook. But this is something, it's worth a reminder, because when these cases hit big, they hit big, because we're usually, these are the kids who in the quiet of the night are sent to a residential facility across the country, and you get a reimbursement claim, and we don't have an IEP to defend. So this is something, tie up this little loose end here when it comes to this. Any comments on this honorable mention?
The only thing I'd add, Jeff, I agree with everything you just said. The only thing I would add is don't sell yourself short in this analysis, in the sense that there's a tendency to think that because somebody with MD after their name has issued a note that says that a student needs to be medically homebound, that's where the analysis begins and ends. And that's really about the worst approach that can be taken, because that doctor, we all know, only signed that letter to get that parent out of their office, right? We all know that's the reality. That doctor does not know anything about the school district, about the level of support that you can provide to students, about the special services that are available. So CSE or the 504 plan, depending on which jurisdiction applies, always has the ability to review an outside recommendation for a health plan. I recommend that you handle those like an IEE, and the case law is clear there. You have to consider it, you have to give it weight at CSE, but you're not required to implement a recommendation from an outside provider, and that includes medical providers. The only disclaimer I would say in response to that is make sure that if you're rejecting an outside recommendation for homebound, that it's based on solid internal evaluative information, and that your providers have a basis for believing that they can serve the student. And the vast majority of mental health issues are going to be better served by having that student in your programs, getting services and supports, and getting that child socialized, than having that child at home. So that's what all of the people I work with have told me over the years. You have those supports in place, and don't think that just because a doctor has issued a note, you're required to honor that doctor's note.
Okay. And now be the first line of defense on that would be at the what if gen ed home instruction stage, like the principal or the nurse. What I've seen is kind of following up on what Kate said. But once the district approves it internally, then they kind of own it. Like, it's funny because the principal is signing off on it. Okay, we own this now. We're acknowledging that this met some threshold. But once you get it into the CSE realm, you're right. That's the right group of experts to say, no, you're not rising to that level. Okay, last slide, honorable mention. This is an easy one. Remind your teachers and related service providers of their obligation to collect substantial regression data throughout the year to prepare for identifying students who require extended school year services in summer 2025. This is, you're going to have to do some guesswork or anticipation about which kids may be potentially eligible, so you could really focus on those kids after breaks. And then if the need is there and there is substantial regression, we've got the data and the student should get it. If not, then if the data is not there, we'll be in a great position to rebut the request. But it's very important to get ahead of this early, and especially for younger kids or kids who might be new to the CSE recommendation process. And I know this is a big issue. You dealt with this over the years, and Andrew, Candace, Kate, any comments on this?
Yes, I think that I think that people have a lot of confusion around substantial regression data, and what I mean are the teachers and the related service providers. So having some refreshers on how we collect that data is important. It's substantial regression on an already mastered skill. It's not substantial regression based on the goals that they're working on this school year. So it would, unless they've already mastered those goals. So it would require first identifying a mastered skill, measuring where the student's performance is before a break, then measuring what their performance is when they return from the break, but then also monitoring how long it takes them to regain that skill after being provided explicit instruction for that. So there's a lot of technical parts that go into substantial regression. And it's important that people come to CSE with data around that they're collecting that over the breaks to help the CSE make that decision if the student is entitled to it.
Okay, anyone else? Kate, Candace, Andrew, anything to add?
No, I think Ann summed it up very nicely. So thank you, Ann.
All right, well, that is the end of our program. Thank you very much for spending some time with us this morning. If you have any follow-up questions, feel free to reach out to any of us. Again, you will be sent the slides and the materials if you registered for this event. And also, it'll be posted on our website. Thank you again. Enjoy the rest of the summer. And we look forward to seeing you in the fall. Take care. Thank you.
Thanks,
Thank you.
folks.
Thank you.
Bye-bye.